Ladies and gentlemen, I appreciate y'all's attention. This has gone quick, relatively quick, although I know at some points it was agonizing. But I thank you for your attention. This has been a very interesting case. You know, there's more than one way to charge and accuse a DUI, but this particular DUI is only charged one way. And that one way does not talk about whether my client was less safe to drive, but only whether you know beyond a reasonable doubt that the test, the chemical test that was given, is accurate. Now, ladies and gentlemen, there are things we can do that affect how the state tries its case. And I would submit to you this is one of those cases. The crime lab person got on the stand, and when I started asking about the fermentation, and this whole issue comes down to fermentation, and I will tell you why. Unbelievably, the blood test in this case was blood drawn at the hospital, despite the fact that the officer said, we're going to go get you a test, just like you want. We're going to do what you want. And they didn't do what he wanted. But what they did with the vials of blood is they went and put them in an evidence locker, basically for a month. And that one's not even refrigerated. The one at the police station, in a locker for a month, all the while decomposing. And as it decomposes, fermentation occurs and alcohol levels increase. This test could have been fixed if they had just done the test that night. Then there would be no argument, there would be no doubt, there would be no way to attack it. It was fresh off the press. Instead, they want you to believe that the vial is somehow already injected with stuff, with some sort of anti-contaminant that keeps the fermentation from occurring. This whole case comes down to this, y'all. I asked her, did you know for a fact that was done? No. Did you test for it? Did you test to see when you did the blood test? Did you test to see if it had the preservative in it? The chemical compound used, the sodium fluoride or whatever, that would keep it from fermenting? No, I didn't do it. They just told us, I've been told it's there. Ladies and gentlemen, they have to prove their case beyond a reasonable doubt on every single level, all right? And they have not proved that that test was not elevated because of fermentation. If they had sent it the next day and it got there, or if they had hand-delivered it the next day to the crime lab and they had done the test that day, the fermentation argument's not going to work, all right, because that's only a couple of days. Did they show any elbow grease in this case to get that test done, fairly done, accurately done, so that there could be no mistakes? No. And they're lazy because they don't come in here telling y'all that this sodium fluoride is in it. They just think that it's in it. No one testified with direct knowledge that those tubes had any preservative in them. Not one person testified from their direct knowledge that that was the case. You know, you cannot convict a man based on that. That is not fair. Oh gosh, I'm so sorry. I don't know why that happened. Ladies and gentlemen, my client, knowing more than the average person about tests, knew that he needed to get an immediate test done with an immediate result back. He asked for that immediate test to be done at Hamilton Medical Center. The policemen acted like they were going along with him, but they weren't going along with him. They weren't going to let them do the test. All right, and you remember that the crime lab person, I got to acknowledge that you should not confuse the terms test with just taking the blood. All right, those are two different terms. And yet, the officer told you to him they mean the same thing. Why does that matter? Because it's unfair to get on the stand and say, well, we accommodated your client. We did what he asked us to do. We took him to Hamilton Medical Center for the test. No, you did not take him for the test. You took him there to get a blood sample that you would sit on for a month in a locker that's not refrigerated, then take it down there whenever it suits you. A month later, at least the crime lab puts it in a refrigerator when they got it. That would at least slow the fermentation down. And I think it's a little disingenuous of that witness to say, oh, there's no problem. The only reason you put it in the refrigerator, and she finally admitted to this, the only reason you put it in the refrigerator is to keep the fermentation from happening, to slow it down. Now, if this magic elixir she claims was in all these tubes was really there, why would they even have refrigeration? There'd be no need for it. Ladies and gentlemen, that's doubt. That is doubt. They have not proven. They chose not to cross-examine my witness. Now, I think that Ms. Baxter did not want to cross-examine my witness because she didn't want you to see that when he is triggered, when his triggers are pulled, he's going to do the same thing here in the courtroom that he did that night. And that's to go bombastic. She didn't want you to see that. So she didn't ask him any tough questions. She didn't ask him any questions. You don't ask the defendant questions, and I know what she's going to say. She's going to get up here and tell you, your only consideration is that test. Your only consideration is the accuracy of that test. I'm telling you, I agree with that. And that test is no way can you say beyond a reasonable doubt that it's accurate and that it's not an exaggerated reading because of that fermentation. All right? I challenge her to get up here and tell you, why didn't they take it that week? Why didn't they take it the next day? Why didn't they take it 2 days later? Why did they wait a month and then take it there and then they sit on it another month before testing it? That does nothing but help them prove all their cases. If they want to do every DUI in the world that day, all they got to do is just take it there, let it ferment, let the alcohol cook up, and then come and convict people. But if you return a not guilty verdict, you're saying, no, I think the crime lab needs to tell us for sure that that chemical is in the tube. And they can tell us for sure if you return a not guilty, then they're going to know next time, hey, you better test that test tube to see if that preservative is in there, that sodium fluoride. All right, you need to tell me that you're certain that it's in this particular tube. And if it's not, then you can't rely on these tests, not to convict a man, not to convict a man or a woman. I told you early on that my client, is eccentric. There's no telling what he's contracted through head injuries, through malaria, through this, through that, how this has all impacted his health, has impacted his mental health, has impacted his personality. The man is a hero, all right? I hope you saw that, no matter what you think of him. The philanthropy and the humanitarian work that he did to care for those who no one cares about, I think the judge will tell you that you're allowed to consider character evidence in this case. And I have put up character evidence. But if anyone deserves the benefit of the doubt, we all deserve the benefit of the doubt because that's the law. But if anyone really deserves it, that benefit, it's someone who's done the amount of work and free charity work that he's done over the years. If we can't be fair to a man like that, and we just toss him aside and say, because we don't like his personality, or because he's too loud for us, what kind of mercy is that? I remember in law school, one of the most beautiful terms I ever heard was that the jury has an enlightened conscience. That between all of you, you have an enlightened conscience. And that enlightened conscience is what helps you determine the facts. A fair representation of the facts. You follow your hearts, you follow your minds, but you also follow your hearts. And ladies and gentlemen, it's funny, not funny, but ironic that his humanitarian organization, Corazon, heart to heart is what that means, is the name of what he does now. He doesn't practice medicine anymore. All right, he practices humanitarian aid to other countries. I ask you to consider that. I ask you to consider one particular charge that the judge is going to read to you, and I will base my defense on this charge. It's called grave suspicion. The judge is going to read to you the facts and circumstances which merely place upon the defendant a grave suspicion of the crime charged, or which merely raises speculation or conjecture of the defendant's guilt are not sufficient to authorize a conviction. You may gravely suspect he might have been, that test might be correct. But here's the confusing thing about this case, and when y'all argue this may well be, discuss this, it may well be confusing. She doesn't come into court asking the officers to examine or testify to the field sobriety. She didn't ask them to comment on, for them to comment on his behavior. Did you notice that? She didn't ask them to comment on anything other than the blood test. And the reason is, she's put all her eggs in one basket. She doesn't care about proving whether he was less safe. She's not trying to prove he was less safe. She's not trying to prove he was intoxicated. She's trying to prove one thing, that blood test is flawless. And that you are to just roll over and say, oh, it must be if it says that on a piece of paper. And I don't know about fermentation. I don't know about any of this. But surely if that woman said that, yeah, I think the chemical, somebody told me the chemical was in that test tube. I don't know myself, and I never observed it. I didn't test for it to make sure it was there. If y'all demand the crime lab to do those things, the next time we come to court in the next case, they will have done them. But as long as you let them remain slack, and this is slack and unacceptable, to let that woman's testimony from the crime lab be certain that it could not have fermented after the officer sit on it for 2 months. Please, y'all, please. You heard me talk about his ADHD. I think you could see that he was hyperactive. I think when you combine that with the cerebral malaria, with the bone leg issues that he described to you on the stand, he's not making any of that up. That's all true. He believes it's 100% true. Could that explain the only 2 exercises he really looked bad on, which is the heel to toe, which is really he just wasn't following instructions. And that's that hyperactivity thing. His actions are going beyond his thought processes. So he's saying things, they get out of his mouth gate before he can close the gate. That's something he has to struggle with every day. But what you have to ask yourself is, what does the fact that no one smelled alcohol mean? All right. The number one thing that officers will tell you is that excessive drinking comes from the smell of alcohol. When they smell alcohol on you coming from your car, coming from your person, that's their number one reason to accuse you and to want to test you for DUI. Neither one of them smelled any alcohol. Does that corroborate my client's testimony that he only had 4 hours earlier or within the last 4 hours? Yes, it absolutely corroborates it. The law in Georgia lets you drink a safe amount and drive. It just doesn't let you drink an unsafe amount and drive. And the unsafe amount is anything above a .08. All right? Now, there's another way you can charge a DUI, but he's not charged that way. He is charged just on the blood amount alone, nothing else. I also ask you to consider he's in his 60s. To expect, I think any sober people, some percentage of sober people, especially 60-year-old sober people who've been through jungles and wars and rifle butts to the head, are going to be a little physically off and maybe a little less effective with their equilibrium. Again, I believe with all my heart that my client deserves the benefit that the law gives him. I believe in karma. I believe if you sow goodness, goodness comes back to you. He's sown a lot of goodness in his life. And I think that in a situation like this, it needs to come back to him through the law and through a fair reading of the law. So I hope that you will not let a sheet of paper that has that reading on it, but with no guarantee that that test was accurate, with no safeguards, with no verification. She's going to get up and wave that reading in front of your eyes. I challenge her right now to get up here and tell you what evidence. She didn't even ask a question about it. What evidence did she present you that fermentation could not have occurred? What evidence? She didn't even ask a question about it. She didn't get the person up here who would know about the test tubes. It's all, she gave you no direct evidence that that was an accurate test. So, y'all, I'm done. I hope that you'll weigh the evidence, that you'll see not only what she asked, but what she didn't ask. And she didn't ask thing one of the officers about How do you take his behavior? What do you think about his behavior? What do you think that meant? She didn't say one thing, elicit one opinion from them about all that. She didn't care about any of that. She wants you to convict on that one piece of paper alone, and it's a piece of paper I truly believe that we have discredited. So after you discuss it, I'm asking you to return a verdict of not guilty. Thank you.